everyone. Today we're going to talk about estate planning, particularly areas of common mistakes that people could definitely avoid if they gave estate planning a little bit more time and consideration during the planning piece. Also, sometimes what you put in place initially is great, but things evolve and they need to be periodically updated. For instance, if you switch jobs, that may mean opening up a new 401k plan and doing something with your old one, buying and selling property. These are all things that potentially need to be updated in your estate plans. Other families a lot of times feel like they don't need estate plans. They think they're young families, they don't have enough wealth to see the benefit in doing it, and it's also a bit of an expense to account for. This is something that I say is a huge mistake because children are likely your greatest asset, and having a correct estate plan in place to account for them is really important. I've had families say, oh, guardianship's all settled, they have godparents. Godparents are not a legal custodian for your child, so naming somebody in your will is really important. So aside from that, let's go over some of the common mistakes I mentioned in my recent blog post. The first is assuming that titling property or an asset with somebody else is a substitute for estate planning. This is sometimes so with a spouse, but not so much with anybody else, including a child. Owning something with somebody else means they really truly own it. So that means exposing yourself to their liability, their divorce, their poor choices, anything like that. So it's an irrevocable gift, essentially, when you co-own something. If you do something similar through estate planning, such as a will, they're not owning it until after you've passed. Another really common mistake I see is that people do create a will or a trust, but they don't realize that a lot of the assets they have don't actually go in accordance to those two documents. So they think, okay, great, I have a will and I'm leaving everything to my children equally. However, certain accounts like an IRA, a traditional brokerage account, even a checking account may have a beneficiary designation on it. Beneficiary designations are an operation of law, meaning that they take precedence over something like a will or a trust. It's actually completely separate. So let's say your IRA, because I've seen this, name's actually an ex-spouse. But you've recently redone your estate plans to account for a new spouse and your children. Well, if you were to pass not having updated the beneficiary designation on that older account, that money is going to your ex-spouse. It happens. So make sure that you're really reviewing not just the documents, but all the beneficiary designations on your various assets. Now, you may have plenty of assets in your estate to cover any settlement expenses. However, have you accounted for the fact that you need some cash available to pay those expenses? If you've really buttoned up your estate plan so that everything avoids probate, what some people fail to understand is that they're either co-owning the asset, so then by operational law it goes to that person directly, or they've named everything as a beneficiary designation, so it just doles out directly. And then you're having to count on all those different inheritors to actually chip back in to pay the expense. While we like to think that people would be so nice to do that, it doesn't always happen. So just keep that in mind as you review that there's some kind of cash pot available to cover those expenses, or that the assets are owned in trust where the expenses would be paid off the top. Each state is a little different in how they calculate estate taxes. So most of us aren't really worried about federal estate tax, but state estate tax is an issue for a lot of people. Now, if you live somewhere like New Hampshire, there is no estate tax for that state. In this case, you have to do some fancy estate planning known as a bypass trust. Now, in some instances, it's worth doing, and in others, it's not. So it's really important to speak to an attorney to better understand if it makes sense in your situation. People get really hung up with gift tax. And partially, I think, because there's an annual exclusion for gift tax that changes every few years. So I often meet people that still think the annual exclusion is $10,000 or $12,000. For 2018, it is $15,000. That means you can gift up to $15,000 in investment, cash, or value to any other person. That's a really powerful tool, because if you do have a larger estate and you're looking to get yourself under certain limits, like the federal, or how I mentioned, the Massachusetts $1 million limit, utilizing a systematic gifting program is really a great tool to transfer wealth. The last common thing to avoid is not utilizing the step-up in basis, which is a huge way to save on taxes. Some families have a home that they purchased a really long time ago that has a really large capital gain on it now. Maybe they purchased it in the 80s for $40,000 and right now it's worth $400,000. If you're just a single person, your capital gains exclusion on a personal residence is $250. So as you can see in that example, even with that exclusion rate, there's still going to be a taxable gain on the property. If they were to leave this property to be inherited by their family, it would get a full step up in basis, meaning that if they passed away this year and the value of the home was $400,000, the basis would turn from $40,000 to $400,000. And that way, the new heirs could decide to turn it around and sell it and only pay any gains on any maybe marginal amount that it had gone up since they had inherited it. If you as the owner choose to sell it now rather than allowing it to be inherited, you're going to either pay the gain right now, or if you choose to gift it, meaning you're going to actually just retitle it to the name of your child without them paying for it, they're actually going to keep the basis that you have. So they're essentially receiving the property at that $40,000 basis. So again, whenever they eventually sell it, the gains is going to be calculated all the way back to the $40,000. But allowing them to inherit it really saves a bundle because it's bringing it up to the current market value. So I hope that helps in figuring out how to move forward with your own estate plans. Please don't hesitate to reach out to me with any questions. I am always happy to work alongside an attorney to get these plans drafted for you and to answer any questions so that you can just dive right in once you do meet with an attorney. Please feel free to subscribe to my blog at powwowllc.com, as well as subscribe to me on YouTube. Have a great day, guys.